Today, we're going to talk about why it's better to inherit property than receiving property as a gift. Hi, I'm Alec at the 𝑾𝑯𝑦𝑻 Law Firm, where we've been helping families with wills, trusts, and probate for 30 years. Now, you may be thinking, okay, what's the difference? Why is it better to inherit property? Doesn't it make more sense to get property while I'm younger? Maybe mom and dad don't need it. Maybe they just want to give me their house. Maybe they want to put my name on title. They've heard that there's advantages to doing so. And there are, whether maybe they have medical assistance planning we're trying to avoid, or we're doing certain spend downs. But for the majority of our clients, it does not make sense to put children's names on the property with them. It makes much more sense for these children to inherit. Now, the biggest reason, capital gains tax. Now, if you gift property to your children, for example, if you sign over your house and you put your children on title to the house, you can do that. The asset's no longer in your name, and now you don't have control of that asset. It does have some benefits, as I talked about, medical assistance. It can help avoid that. But now you lost control of that asset. And when your children go to sell that asset, specifically your house, if they didn't use it as their personal residence, they're going to pay much more in taxes because they have a carryover basis in that property. What does that mean? Carryover basis means they're going to take your basis in the property that because you gifted it to them. For example, if you bought that property for $100,000 and you gifted it to them and then they sold it for $250,000, they're going to be paying that capital gains tax on that $150,000 gain. Whereas if they inherited that property following your death, they would have a much lower tax that's owed. For example, let's use the same numbers. You bought the property for $100,000. Your children then inherited that property when you passed away. The fair market value of that property when you die is $250,000. They never live in it. They just turn around and they sell that property for $250,000. Well, their basis in the property is the fair market value at your death. So the basis is $250,000. The sale is $250,000. There's essentially going to most likely be no tax that is owed on that sale. So it's a huge tax savings for them to inherit the property compared to if they had gotten the property as a gift while you're alive. Now, you may be thinking, okay, what about probate? I want to avoid probate, and we can avoid probate. What we use is called a transfer on death deed. That essentially is a beneficiary designation for your real estate, identifies where your asset should go following your death. If you're married, we can still do that as well. So whether you're single or married, we could do a transfer on death deed that can convey your house to your children following your death, and that avoids probate. And also it allows them to inherit the property, which can minimize the tax that's owed following the sale of the property. Now, if you have any questions about this, you can reach out to us. We can help walk you through different steps, maybe different situations, and come up with a plan that'd be best for you. Now, I'd like to thank you for joining me today. If you have any questions about estate planning or real estate, make sure you subscribe to our YouTube channel to find out when we post another video. Thanks. Have a great day.